Hello everybody and welcome to the second video in our series on the English legal system. This video today is going to focus on some of the terminology which is used when we study law. Now, the first point of note is that since the introduction of the Civil Procedure Rules in 1998, less Latin is being used in court proceedings. However, please note that I have said less and not no, which means that some Latin is still being used. Now, according to Bamford, Taylor and Verlander, the 7 most commonly used Latin words or phrases and their meanings are: number 1, ratio decidendi. This is the reason for the judge giving that particular decision. This is also the section of the case which states the precedent. Number 2 is obiter, obiter dictum or obiter dicta. Dicta is the plural of dictum. Now, this is not part of the main decision given by the judge. However, it is commonly referred to in legal textbooks as things that are said by the way. Now, sometimes there are interesting points made here by the judge, so they can be quite useful. For example, your legal assignments. Number 3 is stare decisis. Now, this is the doctrine of precedent. Number 4 is ex parte, and this is something which is done on behalf of one party to the proceedings. Number 5 is prima facie. So this literally means on the face of it or on first appearance. So what this means in reality is that based on the first appearance or based on the face of it, that evidence will be accepted or treated as valid unless it is proven otherwise. Number 6 is citation. This is where you find the case or the piece of legislation. Number 7 is Interalia. This means among other things, and it's used when stating what is contained in a class of things. So for example, you may have a lawyer in court and they are stating what the client had to do as part of their job. So they may say something like, Mr. Smith had to inter alia photocopy, make the coffee, make the tea, serve customers, for example. Now let's have a look at some of the English terminology that is used in the English legal system. In a civil case in English law, the parties are called the claimant and the defendant. Now, in a criminal case, the parties are the prosecution and the defence. In both the civil and criminal cases, if the losing party decides to appeal, they are called the appellant, and the respondent is the party that they are appealing against. In a criminal case, the prosecution prosecutes. In a civil case, the claimant sues. In a civil case, the court decides who is liable, whereas in a criminal case, the court determines guilt. Notice I've said determines guilt and not decides guilt. Criminal cases can also start with the initial R, for example, R.V. Williams. Now here the R stands for Regina or Rex, literally meaning the Queen or King of that country. In a civil case, the V in the middle of the parties' names means and, whereas in a criminal case, it means against. Probate cases are those which are concerned with the distribution of a dead person's property. The cases tend to begin with re. For example, re Jones deceased. Now here, re does not technically mean regarding, it means in the matter of. Shipping cases may only mention the name of the ship. For example, the Wagon Mound, which is a case dating back to 1961, but if you study tort law, there's a very good chance you will actually study this case. Cases involving vulnerable parties, for example, children, may only use a letter, for example, the letter P. So the case will be called re P. Another distinction which exists in English law is that between public and private law. Public law is concerned with the relationship which the individual has with the state, and private law is concerned with the relationship that individuals have between each other. One further term which can confuse people is common law. Now, as Bamford, Taylor and Verlander state, it actually has 3 meanings, and this is because firstly it can contrast with the civil law which exists in countries that have codified systems such as Italy. Now here the term civil means that the law is based upon Roman law, especially that of the Emperor Justinian, which was in the Corpus Juris Civilis. Secondly, common law can contrast with legislation. So common law was earlier and it originated from custom and judge-made case law. The final meaning that's used can be contrasted with equity. Now the key difference here is with regard to the remedies that are available. Now there is a unified court system, so common law and equity are joined. However, this has not always been so. Common law remedies include damages, Whereas equitable remedies, these are typically either an injunction or an order of specific performance. Now, these will be dealt with in future videos. Thank you everybody for watching this video today, and I hope it has been useful for you.